Hello, everyone. Thank you for joining us today for the COVID-19 update. We're going to be going through the current status of COVID-19 regulation and what employers need to do to be in compliance and to reduce risk in their workplace for both fines and illness. So just a reminder here that we're not giving specific legal advice for your workplace. Rather, we are giving general information here today to help you to know where resources are on COVID-19 and what the general overview looks like in terms of regulation and legislation. My name is Jamie Bossuat, and I am a lawyer at Kroloff. I practice civil litigation with an emphasis on employment law. So a lot of my practice relates to employment law. I do policy development, employee handbooks, advice on different regulatory issues and employee concerns, and then I also litigate cases all the way through trial. So what we're going to cover in today's presentation is here. Here's our outline. First, the regulatory approach that is currently being taken in California, requirements for masks that are currently in place, current regulation of vaccines, workplace safety, and what to do in the event of a COVID exposure. So California's regulatory approach has changed over the last 2 years. And right now, both federal and state law actually converge on this. They encourage vaccinations. They require vaccinations in some sectors. We'll go through that. Encourage masking in all public places, and then with requirements for masking in some situations. Testing for those who feel ill and in certain sectors more regularly, and then some more specific rules for mega events in terms of checking vaccination status or COVID-19 testing. And so the overall kind of business restrictions have lifted statewide, but we do still have an obligation to keep our workplace safe, and we'll go through that in the Cal OSHA and workplace safety section. So mega events are those that are more than 1,000 people or 1,000 or more people indoors or 10,000 or more outdoors. So this would apply, for example, to conventions, conferences, expos, concerts, shows, nightclubs, sporting events, live events and entertainment, festivals and parades, theme parks, large events or gatherings, races, marathons, car shows, all of these types of large gatherings. Attendees for an indoor event with 1,000 or more people must provide proof that they are either one, fully vaccinated, meaning 2 weeks after the last dose that's required in a 2-dose vaccine, or the 1 dose of the Johnson & Johnson vaccine, or they have to provide proof of a negative COVID-19 test. And they cannot any longer self-attest. They have to provide documentation of this. And coming up here shortly on December 1st, they will need to provide identification at the mega event to prove that they're the person whose vaccination card or test result they are showing. So this is for events indoors with 1,000 or more people. Now, there are a lot of venues statewide, and there are more stringent requirements in some counties and cities that are requiring vaccination or testing for smaller numbers of people indoors. So they are allowed to do that if they want to, or if a county or city requires it. Here in San Joaquin County, there is no such mandate, but there are private venues that are making the decision to seek vaccination for events with fewer people. Now, outdoor events, 10,000 or more people, here we're talking very large community events. These are recommendations from the California Department of Public Health, not mandates, but the recommendation is that attendees provide proof of vaccination or a negative COVID-19 test. So this could be checked, for example, at the exit to a fairground, the entrance to a fairground, which you care about more than the exit probably. But that would be something. Street events, for example, a little harder to check because people are wandering in from all different locations. And I think that's why this is a recommendation, because in some outdoor venues, it's simply not possible to check the status of everyone participating in that event. There's a recommendation that attendees not self-attest and that instead the venue check documentation. And then beginning December 1st, 2021, there's a recommendation that that documentation is checked against ID. Okay, so that is the end of the section generally on how California is approaching the pandemic at this point and mega events. Any questions on that area? Okay, seeing none, we're going to move on to masks. So here we go. In California right now, masks are required for everyone, vaccinated and unvaccinated, on public transit, in healthcare settings, in adult and senior care facilities, indoors in K-12 schools, childcare, or other youth settings, in state and local correctional facilities and detention centers, and homeless shelters, emergency shelters, and cooling centers. So these are requirements for masks for everyone. And these are, condensed areas indoor typically where there's quite a bit of potential for transmission. So that's where we see the mask mandates for everyone. Masks are required for unvaccinated persons and recommended for vaccinated persons in retail, restaurants, theaters, family entertainment centers, meetings, and state and local government offices that serve the public. There are exceptions to the mask requirements. Children under 2 years old do not need to wear masks because they present a risk of suffocation. People with medical conditions or health conditions or disabilities that prevent them from wearing a mask, for example, those who cannot remove the mask without assistance if they were having trouble breathing, do not have to wear a mask. Persons who are hearing impaired or who are communicating with someone who are hearing impaired and they need to see the mouth to communicate do not need to wear a mask. And if there is a type of work for which wearing a mask creates a risk, for example, maybe a swimming instructor, where it would get wet and make the work risky, that is an area in which the mask is not required. Masks in non-mandatory settings. So this is your private business. There's no mandate for private business that there be masks required for all persons. But it is okay for a business to ask patrons to self-attest that they are in compliance. Well, this is I have mixed vaccines and non-vaccines in this slide. So you can ask for vaccination status prior to enforcing your mask mandate, for example. And you can ask people to self-attest, or you could ask for a vaccine card. You can do more than the law requires. You cannot prevent someone from wearing a mask if they want to do so. So anyone's allowed to wear masks. And you can also require people to wear masks in your place of business. So you can require more than the state or the county does. I have a question here that I'll get to after this slide. County mask mandates they were in place in these counties. I did not check these because it's been evolving very rapidly. And now COVID numbers are going up again. So these are the counties into the fall where there were mask mandates in place. So one thing to note is that if you have employees traveling or working in these counties, you want to advise them of the mask requirements in the areas in which they will be working and make sure that they comply. Cal OSHA has some mask rules for us. It recommends all employees wear face coverings indoors regardless of vaccination status. Unless you're in a county that requires that, it's not a mandate. Unvaccinated employees have to be provided N95 masks to use indoors at their election. Masks in general, face coverings, have to be provided to all employees who request one. You can't prohibit an employee from wearing a mask who may want to do so voluntarily. And you can mandate masks in your workplace in line with the recommendation. if you make accommodations for employees who are excluded from a mask mandate rule, which we discussed a couple slides ago, those who are disabled or the work prevents it from being safe. I'm going to look at this question here right now because I believe my next slide is on vaccines. Oh, this question is about vaccination status and employees not wanting to provide proof of vaccination. And the question is it legal to make copies of CDC cards for all employees? Yes, it is, but that is medical information. So that would need to be maintained in a confidential location, separate from other employee records and protected with only those with the need to know receiving the information. Any other questions on masks before we move into that category? The next topic we're going to go over is vaccines. Okay, moving on then to vaccines. So this is a little vaccine chart that I pulled down from this morning from the state's website, where you can see the levels of vaccination across the state, 1+ dose vaccinated, and the share of the population vaccinated there. So I just thought this was interesting. We're getting quite a bit of vaccination spreading across the state in California. So vaccines are now available for 5 and above. That's on a temporary authorization for 5 to 11. 18 and above is a full authorization at this point for some of the vaccines. That's evolving as they apply for their different approvals. Booster shots are available for most of the population now, or much of the population, maybe I should say. And this is a little excerpt from the California Department of Public Health. I have the link down there on the bottom. The California Department of Public Health has, you'll see I linked to their website in a lot of these different pages because right now they are the best resource for information on vaccines, boosters, mandates, all of that. Also, the COVID-19.ca.gov website is something that you'll see cited in a lot of the slides. That's still a great place to go for current information on state regulation, because County of San Joaquin does not currently have mandates that are different than that of the state, and the state's websites are a great place to look. So you can receive a booster of Pfizer or Moderna, and it's recommended if you received your second dose at least 6 months ago, if you're 65 or older, if you're above the age of 18 and live in some of these high-risk conditions. The Johnson & Johnson booster is recommended if the vaccine was received 2 months ago and you are 18 and older. Let's see, I have a question about masks that I'm going to come back to. Unvaccinated employees are not required to wear N95 masks, but you have to make them available to those employees under the current Cal OSHA standards if they want to wear one for their own safety in the workplace. So we have quite a few vaccine mandates in place now. Between August and the present, these have been released. So the first that we saw in California was healthcare workers. We're going to go through that one in detail because the others are similar in scope to that. School employees, state employees, workers at high-risk congregate settings, adult and senior care facilities, settings within which direct care and services are provided to the elderly or disabled, such as through the regional center system or facilities licensed by community care licensing. And then there will be a mandate for school children once full federal approval is obtained for the particular age groups that apply. I have another slide on this with more detail. From what the governors, through the regulatory process, this was passed rather than through legislation. And so there's a personal belief exemption in it currently, but that could change. So we'll see how that goes. And then we saw the federal OSHA requirement come out a few weeks ago where private employers with 100 or more employees have to show proof of vaccination or once a week COVID test. That's currently stayed by one of the federal district courts. And we'll see what happens with that. Most articles and information I've read seem to think that it will remain in place to some extent, and that employers are being cautioned to prepare for this in the event that the stay is lifted. So I've got a couple questions here. I'm just going to take those real quick. Oh, the definition of persons at increased risk due to social inequity. I do not know the answer to that question. That is a healthcare question. So with regard to who should receive boosters, I think this is important for employers to know that it exists. Their employees are going to be receiving them. I think it's very likely that at some point boosters are going to be required. Just like the annual flu shot is, we don't rely on last year's flu shot for those who require flu shots in the workplace in healthcare settings. For example, we need a current year health flu shot. But I'm not a medical professional, so I don't know what the requirements are or recommendations are for who should receive boosters, other than what I pulled down from the California Department of Public Health. I would recommend that you tell your employees, if they're asking you, is to ask their physician. COVID pay, my next question here I see is on COVID pay. We'll go through that in a moment. And I'm having a question on receiving a copy of the slides. Yes, if you would like to receive a copy of the slides, please send me an email and I will send you a copy of the slides. Please don't put it in the chat or the Q&A, because that disappears for me at the end of the presentation and I don't have a list of you anymore. So please email me. My email will be at the end of the presentation. Or you could respond to my email is also in the link that you got for the presentation. So these are the current vaccine mandates. So we're going to go through the healthcare exemption a little bit more detail because it was one of the first, and it the others are similar. So who is covered? General acute care hospitals, skilled nursing facilities, intermediate care facilities. So we go through dialysis. So each of the laws, including the one that covers schools and community providers for the disabled and elderly, those all have in them a definition of who is covered. And what's interesting in these laws is that as with the definition of healthcare worker, it's not just the people providing direct service. So it's not just a nurse in a facility. It does include nurses, nursing assistants, physicians, but all workers in the facilities, including paid and unpaid, so even volunteers who are present in settings where the care is provided to patients or have access to those areas, are covered under the mandate. So that would include also, for example, technicians, therapists, students, trainees, contract staff, so independent contractors that come into the facility, or clerical employees, environmental services and janitorial employees, laundry employees, all of those that are present in the healthcare settings. Okay, just looking at my Q&A, and I'm going to get to those questions in a moment. So what is required for healthcare worker vaccinations under the mandate? Workers must have their first dose of the one-dose regime by September 30th, or the second dose of the two-dose regime by September 30th. And the other laws, as they've rolled out, have their own enforcement timelines. All COVID-19 vaccines authorized by the U.S. Food and Drug Administration or the WHO meet the requirements for this. What are the exceptions? And the exceptions are applying across the board for all of the mandates that we're seeing. There's an exception for a religious belief, a sincerely held religious belief, and there's an exception for a qualifying medical reason. So employees are asked under the healthcare worker mandate, for example, to provide a statement by their physician, nurse practitioner, or licensed medical professional that they qualify the exemption for the exemption, and then the probable duration, whether that's indefinite because it's a permanent type condition, or whether due to some medical treatment they're receiving, and they're expected to be able to receive the vaccine in 6 months, for example, so that the employer sorry, can plan for when that person could be placed into the workplace. Religious beliefs, we're going to go through in a moment on a different slide. Healthcare workers who are exempt, either due to the religious belief or the qualifying medical reason, have to meet the following requirements when entering a healthcare facility. They have to receive twice weekly testing for acute healthcare and long-term care settings, and once weekly testing for other healthcare settings. And the other laws that we've seen passed are once weekly testing as well. Testing must be either PCR or something with an emergency use authorization by the FDA, an antigen test with an emergency use authorization. Employees who are falling under one of the exceptions and doing the testing option under this law have to wear a surgical mask or an N95 mask at all times while in the healthcare facility if they are not vaccinated. So here's some more information on religious beliefs. This is an area in which I am getting a lot of questions. So this does not need to be an express tenet of the religion, but there has to be some religious foundation to it. It has to be something tied to a religious foundation rather than just being someone's way of life, a healthy lifestyle, for example, or philosophy. It doesn't require a connection or a belief in God or a supreme being to qualify as a religious belief. But it does have to address fundamental and ultimate questions having to do with deep and imponderable matters. You can tell these definitions came out of the cases that have been written on different challenges. And it has to be a comprehensive belief system rather than just an isolated teaching, such as that vaccines are unhealthy, for example. So this is kind of the foundation for evaluating religious beliefs. The community care licensing requirement that came out from the California Department of Public Health required employees to submit written, so does the medical health care, written documentation regarding their religious belief. I do have some clients who are using a form that their employees can fill out and check boxes and then provide an explanation as to why they have or why they need an exemption, I should say. So it goes through these different elements and asks them to attest to what it is that their religious belief prohibits. The level of enforcement of this really varies across industries and businesses based on the preference of the business. There's a lot of concern that some businesses are enforcing these too heavily, and there's a lot of concern and that people should have more freedom of religion. And on the other end, you have people that basically they'll take anything in writing that the employee is willing to attest to. They don't challenge that, and they just make sure that they have their documentation in place. So how strict an employer is going to be based on, I think, both the type of their business, how much risk is there to the population that they're serving, how much ability is there to put in place social distancing and masking and other things that protect people. So how much risk do you have if there was an exposure? And what are your individual beliefs on how you want to run your business? And how invasive do you want to get into looking into people's beliefs? Do you want to be questioning them or not? Now, you can't take a documentation from an employee that's obviously false or that is clearly not reasonable. If someone is, practicing a particular religion openly and obviously in the workplace, and they bring you a note saying, oh no, I can't because now, I'm also another religion, or a letter from church, for example, they've told you they don't attend. You do have some obligation to not accept false documentation, but the spectrum of what you accept and how much inquiry you're going to make into whether it's a sincerely held belief is a case-by-case basis. And so if you do have employees who are having concerns about their religious beliefs, and you're questioning them based on the spectrum of your risk. And that is something that I would recommend you reach out to counsel on and kind of discuss in order to determine what approach you want to take with that employee. Okay. Oh, I have a couple questions. 1 second here. So for the vaccination status of employees, you are required to maintain documentation of vaccination status under these mandates. So you would put that in a similar file to where you put someone's TB tests, someone's medical documentation for their leave of absence, all that kind of health protected information can be maintained separately, but these does need to be maintained under these mandates. So you do have to keep copies of that. Can the employee do one or the other? I think that means religious beliefs or medical. They could do both. If they have a temporary medical condition and also a religious belief, they could give you both, I suppose. And one would be temporary and the other would be more long-term. Can we mandate N95 masks in the workplace, even though we don't fall under a mandate for N95 masks? Yes, you can. If you think that that is necessary for the safety of your workplace based on how your workplace operates and what it is, that is something you can require. You would have to make those exceptions for individuals who cannot wear the mask. So you're going to need to accommodate disabilities if you're requiring N95 masks in your workplace. Okay, moving on to the next slide. With vaccine recommendations and mandates, you want to be aware of disability-related inquiries. So the medical professional who provides documentation that this employee can't receive the vaccine or is not medically recommended to receive the vaccine for 6 months doesn't need to tell you why. They don't need to tell you that it's due to the employee's cancer treatment, for example. That's impermissible disability related inquiry. So you cannot ask particulars about why that individual cannot receive the COVID vaccine. You just need to know that due to a health condition, they can't. You should maintain vaccine records separately as medical records. And then you should also be aware that the Cal OSHA guidelines and reimbursement requirements and compensation requirements for employees being under the control of the employer do require you to provide time off to receive the vaccines and also pay for that time off if it's a mandate within your company. And also the Cal OSHA standards, if you're requiring mandates or time off for any COVID related requirements, require some exclusion pay and pay for that. So be aware of that. This is the OSHA, federal OSHA, temporary standard relating to mandatory vaccines. So employees who remain unvaccinated have to produce a negative test result on at least a weekly basis in lieu of vaccination. And it applies to employers with 100 or more employees, but doesn't prevent employers from requiring something that's more stringent. So this is the new federal standard that came out and has been stayed by the courts. So we'll see what happens with this. But this is for private employers, all private employers in any industry with 100 or more employees. And Cal OSHA is expected to kind of adopt this same standard without much modification at this point in time. Because we have our own California OSHA department, they have to enforce the minimum federal law, but then they can add on top of that. And so that's why we expect to see Cal OSHA to pass a regulation in line with this federal standard. School vaccine mandates is next. COVID-19 vaccinations will be added to the list of vaccinations required for schools. This is once they receive full approval within the age span. So the emergency temporary approvals that we're seeing for like 5 to 11 right now do not require that students be vaccinated. So they'll be required to be vaccinated for in-person learning starting the term following full approval. Approval for 5 to 11 will correspond to a mandate in grades K through 6. And approval for ages 12 plus will correspond to a mandate for grades 7 through 12. And this will be implemented in, apparently, we'll find out exactly how, but in the same manner that other vaccines such as chickenpox, measles are implemented through the state system. And like I said, because of the way this is being approved, at this point in time, we're expecting to have a personal belief exemption, but that's something that we should follow. We're not sure if that will remain in place. Okay, my next section is workplace safety. So I'm going to go back through my questions on vaccines real quick here. Yes, you'll be required to pay for time off for vaccinations if you're requiring them in the workplace. Employees can also use their sick time, vacation, etc., to be paid for that time. Here we go. If the employee has a reaction to the vaccine or tested positive for COVID-19, are we still required to pay? So if you have a vaccine mandate in place and the employee experiences an adverse consequence, then they need to be provided time off for that because it was work related. Private companies, not local. Oh, does the government mandate under the OSHA standard apply to private companies or local governments? The OSHA standards typically apply to all employers. I have not seen an exemption specifically for public entities, but I would have to check. If you'd like to email me that question, I can follow up on it for you. Okay, moving on then to workplace safety. And we're going to get into employee leaves of absence and exposures and pay shortly. So if you ask those questions, they're coming up. Okay, just a reminder, this is what we're going to cover in this section, but every employer with one or more employees has to have an injury and illness prevention program in place. We have California emergency temporary standards that are currently in place to create healthy and safe workplaces. We still have requirements in place for COVID-19 infection prevention programs, and we still have the workers' compensation presumption in place, and we're going to go through all of those just briefly. But this is the general standard in California. You have to provide your employees with a place of employment free from recognized hazards. COVID-19 is a recognized hazard, so that's included. To create an injury and illness prevention program, we have some templates that are up on the dir.ca.gov website, which is linked there below. They have an injury and illness prevention template that you can use, or you can look at to update yours if yours is quite old. They also have a model COVID prevention plan that you can look at as well. One of the, you'll remember back in the spring, we reopened, there were a lot of, and last year, all of those Cal OSHA and Department of Industrial Relations guidance documents for safe reopening. So those documents are not in place anymore necessarily for the purpose of reopening because we have reopened, but they do set out Cal OSHA's recommendations for what you need to do to keep your workplaces safe from COVID-19 hazards. So those are great documents to look at when evaluating what you need to do to keep your workplace safe. Every workplace is unique, every industry is unique. And those are a great template to go through to figure out, what do I need to do to be meeting this general standard to create a workplace that's free from recognized hazards. And the Model COVID Prevention Program goes through a lot of those. So when you're fleshing that out or preparing it for yourself, just because we're now in a much more stable place in the pandemic, it doesn't mean that employers no longer have an obligation to create a safe workplace. So if it's possible to keep people 6 feet apart, then you can include that, and you'll have to exclude less people from the workplace, etc. Even though we don't have those being enforced as hard and fast rules right now. So the COVID prevention plan does have to have these required elements in it. How are you going to communicate it? How are you going to identify and correct hazards? Are you going to require face coverings? When, where? Are there any administrative or engineering controls that you can put in place? Can you spread people out? Can you take away some chairs? We still see those in a lot of workplaces, and that's because they're continuing to enforce those items to keep the workplace safe. How are you going to respond to and investigate cases in the workplace? How are you going to train employees? What testing is going to be required in your workplace? Who are you going to exclude? And then what records are you going to maintain? All employers are covered by the Cal OSHA emergency temporary standards, except for workplaces with only one employee who has no contact with other people, in-person contact, I should say, employees who are working from home, employees who are covered by the aerosol transmissible disease regulations, such as healthcare workplaces, and employees teleworking from a location that was chosen by the employee but isn't under the control of the employer. If your employee is a remote employee who likes to work from Starbucks, for example, then they would not be covered because that's at their election and it's not under your control. So the June 17th emergency temporary standards are still in place. That's the most recent update. Fully vaccinated employees without symptoms do not need to be tested or quarantined after a close contact. No face coverings are required indoors, except during outbreaks, but we do have the statewide recommendations that we went through. Employers have to provide unvaccinated employees with masks upon request. There aren't physical barrier requirements any longer, except during an outbreak. And if you think that that is a reasonable precaution to put in place in your workplace, or if you've already put it in place and you don't want to remove it. And you still have to be providing training on COVID-19 prevention in your workplace. The emergency temporary standards require that you offer testing to employees at no cost during working hours if an employee is exposed in the workplace. You have to notify a local health department within 48 hours or 1 business day of learning of an outbreak. I have that on another slide as well. That's been updated actually. You have to maintain a record of all COVID-19 cases and notify employees and representatives. We'll go through notification requirements in a moment. And you have to report serious injuries or death to Cal OSHA immediately. And we're going to go through that as well. So an outbreak is 3 or more cases in a 14-day period. A major outbreak is 20 or more cases within a 30-day period. Cal OSHA recording requirements. If you are a high hazard employer with log 300 requirements, then you must record an injury or illness that results in death, days away from work, restricted work or transfer to another job, medical treatment, loss of consciousness, or significant injury. It has to be confirmed to be recorded. So that applies to COVID as well. You have to report to OSHA, not just record in a 300 log, if there's a serious illness, injury, or death of an employee, and this applies to all employers, not just high hazard employers. Within 8 hours, if there's an inpatient hospitalization, if the employee became sick at work, or if the employee became sick at home, has to be work-related, and some factors that would lead you to conclude that the COVID case was work-related are that there are multiple cases in your workplace, the type, extent, and duration of contact that employee had with others, if they've been out absent or on vacation for several weeks, probably not work-related, for example, if they worked alone for the last week, or they only came into contact with one person who had no COVID exposure, less likely to be work-related. What physical distancing and controls do you have in your workplace? If they stayed 6 feet away from everyone, because you put those kind of controls in place, then it's less likely to be a work-related transmission. And did they have contact with anyone with COVID-19 symptoms, either in or outside of the workplace? And you have to report this serious illness or injury or death, even if you don't yet have confirmation of COVID-19 symptoms. You have to report still to your workers' comp carrier within 3 days of an employee testing positive, regardless of whether it's work-related or not. You have to provide notice to all employees, subcontractors, and independent contractors who were at the work site within the infectious period who may have been exposed to COVID-19. So this has been clarified that this is a work site level notification. You would also have to provide a written notice to any representatives, such as unions or employee representatives like attorneys. You have to provide employees with COVID-19 related benefits that they may be entitled to, workers' compensation benefits they may be entitled to, any COVID leave that they may be entitled to, paid sick leave, and then your anti-discrimination, harassment, and retaliation policies, as well as your disinfection protocols and safety plan. So COVID leave has changed. We're going to get into that in a moment. So you might want to be updating these documents based on what's currently in place, because, for example, the federal and state COVID sick laws have expired. So here's the, back one. Here's the Cal OSHA emergency rules. You have to report information to local public health agencies within 48 hours or 1 business day, whichever is later, after learning of sufficient positive COVID-19 cases to constitute an outbreak, as defined by the Department of Public Health. And there's the link for you. It sometimes changes. It hasn't lately. Their notice period for serious citations has been reduced, so employers should act promptly to provide notification or to provide documentation in any Cal OSHA investigation. And you're strongly encouraged to consult counsel if you have a confirmed case of COVID-19 or if you have a Cal OSHA inspector appear at your workplace. For those of you who are still looking to encourage vaccinations at your workplace, or maybe a mandate has come out and you want to provide vaccination options to your employees, either on-site or off-site, there is this website that is still up online, saferatwork.covid19.ca.gov, which provides an employer vaccination toolkit with some options for you. I'm looking at the Q&A now because the next section is COVID-19 exposures. Question is, are remote employees required to follow a company mandatory vaccination policy? This is going to depend on what the mandatory requirement is. So if you have a mandatory vaccine policy for your company, that is not mandated by state or federal law, then you can set the requirements. However, you're getting away from business necessity to some extent when you have a work from home employee who doesn't come into contact with customers or others. So there's less need, I think, for that and more potential for objection. However, The state and federal laws, you'd want to determine which law you fall under, each slightly different in terms of which of your employees have to be vaccinated. For example, the healthcare law doesn't require employees working from home to be vaccinated because it only requires those in the healthcare facility to be vaccinated. So that the work from home employee would not need to be vaccinated in that instance. If you have specific questions about vaccine mandates, religious exemptions, medical exemptions, those are areas of high liability because you could have claims from one side, potential exposure, claims from the other side, employees who have claims that their religious rights are being violated. And in that respect, that creates more liability from the employer from both sides. So I would recommend contacting counsel if you have specific questions in those areas. Okay, if there are no more questions relating to workplace safety and Cal OSHA requirements, we're going to move on to what to do in the case of an exposure under the current law. Okay, and this will cover leave. What we're going to go over here is who has to be excluded from the workplace in the event of an exposure. So a close contact must be excluded from the workplace. That is someone who came within 6 feet of an infected person for 15 minutes in a 24-hour period. And that's 15 minutes collectively. So that could be 3 5-minute meetings in a 24-hour period. And that would mean that person has been exposed and had a close contact. And someone is infectious the 48 hours before symptom onset or 48 hours prior to a positive test result and until they're cleared. So we look at the last, so for example, if Susie tests positive for COVID-19, Susie was in the office on Monday. She had a scratchy throat, she went home. She was only there for a few hours. Then on Tuesday, she decides to take a COVID test because her scratchy throat continues. Wednesday, we get her positive test result. So we look back and we say, okay, Susie developed symptoms on Monday. So she was infectious beginning 48 hours prior to that scratchy throat. So Susie was infectious Saturday morning through the last day she was, well, still is infectious. So Susie exposed people in the workplace Monday morning until she went home sick. So this is one of the reasons that we encourage you to really strictly enforce your policies, which require employees with symptoms to not come into the workplace. That is one of the best things that you can do to avoid taking exposed employees out of the workplace. Now, the exposure is going to be different for vaccinated employees, which you'll see. But this is one of the things that as the pandemic progresses and as it goes on and on, employees are becoming increasingly frustrated by is that normally a scratchy throat that could be attributable to allergies or a minor cough that could be attributable to chronic asthma would not require them to take a sick day. And now it does. And so this is something that we're constantly weighing in terms of employees. The more employees you have vaccinated, however, the less employees you'll have to take out of the office, because there's no longer an exclusion requirement for a vaccinated employee who has been exposed if they don't develop symptoms. Let's see if I can get my next slide to come up. Come on, there we go. So someone who, isolation is what the period we refer to where someone who has tested positive for COVID is required to stay away from others. So isolation can generally be discontinued 10 days after the onset of symptoms along with the resolution of fever for 24 hours without any medication and the improvement of other symptoms. So they don't have to be completely cough-free because people are having lung irritation and complications for months, even though they're no longer infectious, but they have to have an improvement of symptoms. And some individuals who may have been hospitalized, for example, who had severe illness, may be contagious for longer. So they may need to extend their isolation. So you will rely on the release from a physician for those people. Exposed people are subject to quarantine. So they might not have tested positive, they might not be exhibiting symptoms, but they would need to stay away from others for the quarantine period. Unvaccinated employees who had a close contact have to be excluded from the workplace for 10 days since their last known close contact. If they develop symptoms and test positive for COVID, then we're going to have them follow the isolation rules that were on the last slide. There are exceptions for quarantine for essential workers during staffing shortages. Agricultural workers have been added to the list of essential workers as of the last legislative session. Fully vaccinated employees do not need to be excluded unless they develop symptoms. However, you can require them to wear a mask during that period, and that is recommended by some public health organizations. So this is the benefit of having employees that are vaccinated, is if you have an exposure in the workplace, less people have to be excluded. Employees with a positive COVID-19 case in the last 90 days also do not need to be excluded, but should be asked to wear a mask. And employees should be required to social distance to the extent possible and to wear their masks until day 14 rather than day 10. COVID paid sick leave has expired under both state and federal law. So under the Families First Coronavirus Relief Act and its subsequent extensions in the California Paid Sick Leave Act, the California COVID Sick Leave Supplement, there is no longer pay for COVID-19 illness when caring for someone else or when the employee themselves is ill. So what we're going to look to at this point in time is our existing leave laws. So we have California paid sick leave. All employers in California must provide at least 3 days of sick leave for employees to have paid time off for an illness or preventative care. That would include vaccines, preventative appointments, COVID-19 illness. So that is currently in place, and an employee would be entitled to leave under that law or whatever your policy is for sick leave. If they have been exposed in the workplace, workers' compensation leave is going to apply. The California Family Rights Act was expanded to all employers with 5 or more employees last year. And I have another slide on this because it's new for some smaller employers. So we'll go into that in more detail. The Family Medical Leave Act applies for a serious health condition for an employee or their family member for employers of 50 or more. Employers in California with 5 or more employees must accommodate disabilities, and long COVID or severe COVID with a lot of remaining symptoms could qualify as a disability under both the Federal Americans with Disabilities Act or the State Fair Employment and Housing Act. And that requires an employer to engage in the interactive process with the employee to determine what accommodations are necessary to allow the employee to fulfill the essential functions of their job, and then to grant accommodations which do not pose an undue hardship on the employer. So this could be, for example, an extended leave of absence. This could be the ability to work from home for a period of time. This could be a modified work schedule. It could be a lot of things that gives an employee flexibility with regard to leave because of COVID-19 illness. Also, we have school and childcare leave that's in place in California, and this is one that's less known, so I've included a slide on that coming up as well. In terms of wage replacement, so we like to differentiate between a law that gives a protected leave of absence, right? The ability to keep your job while you're out, versus wage replacement, which is a law that requires that you be paid for being out. So there is Cal OSHA exclusion pay under the emergency temporary standards. If you know that you're, or have researched it and determined through your investigation that your employee was exposed in the workplace, they have to be paid for the time at which you are requiring them to stay out of the workplace. That can be offset by other types of paid leave, or if the employee becomes ill, for example, state disability benefits they're receiving on their own behalf. Paid sick leave would cover an absence potentially. And then workers' compensation may cover the absence if the employee was exposed in the workplace. So the employee who becomes ill due to a COVID exposure in the workplace could receive workers' compensation benefits. I'm going the wrong way. There we are. Also, there are a lot of localities that are requiring COVID-19 sick leave. This is evolving. So this is not necessarily a complete list here. This was the list that we had going into the fall. And I know they are being revised periodically as the pandemic progresses. So if you have employees working in other cities, we don't have one in place in San Joaquin County or in Stockton right now, or in our local cities here in San Joaquin County, but other cities including Santa Rosa, Sonoma, San Mateo, Sacramento had or have COVID-19 sick leave policies in place. So if you have employees working remotely or employees that, so even if your employee is working remotely from one of these cities and their home office is in San Joaquin County, this may apply. So you want to be aware of that, and also your employees that are traveling into other cities for work. So going back to explaining the California Family Rights Act here, employers with 5 or more employees have to apply this law in their workplace. The definition of family members has been expanded. It was expanded in January and again with this legislative session. So as of January 1st of next year, the categories will include siblings, grandparents, grandchildren, domestic partners, and parent-in-laws. That's the new category that was added as that last one. So if someone in one of these categories has serious health condition and requires the care of your employee, then the California Family Rights Act would apply and would protect their job. It doesn't require a wage replacement. Maybe there's something else that does, but it does require their job to be protected for up to 12 weeks of absence. Now, there are some thresholds for this. You have to have worked for the employer for a year. You have to have worked for 1,250 hours in the 1-year period preceding the leave. So you want to know the requirements for this and implement it correctly. But a lot of small employers are new to implementing this, which is why I go over it here, because it's one of the things that's going to protect jobs for those with severe COVID. And we also have California School and Child Care Leave, which covers employers with 25 or more employees. They're required to provide up to 40 hours of leave per calendar year for school-related emergencies, including school closures. That could be due to COVID as well. You can require your employees to use their paid benefits for this time off, and you can allow the employee the option to use paid sick leave. I'm just going to go through the last slide quickly because I realize we are running out of time. There were laws passed this year pertaining to rehire rights for employees who were laid off due to COVID. So SB 93 establishes rehire rights for employees in the hospitality and business service industries who were laid off for COVID. And this is going to remain in effect until December 31st, 2024, when it expires, if it's not extended. So if the employees meet these categories, they have to be given the right to be rehired over a new applicant. And here on this next slide is the types of businesses covered by this law: hotels, private clubs, event centers, airport hospitality operations, airport service providers, and building services, which the big one I think is janitorial and security. So if you have employees who've been laid off in any of these industries, this law would apply to you. And I encourage you to make sure that you're complying with that when you go through your hiring process as you increase the number of employees that you have. So if you would like a copy of the slides, my email address is here on the last slide. Please feel free to email me and I'll get you a copy of those. I'm going to look over at our Q&A now. Feel free to add questions. I'll stick around here for the next few minutes answering any that you have. You can use those in the chat box or in the Q&A. Okay, I'm just reviewing them here and kind of lumping these categories. So this question is, I think I've answered some of these. So I have, if an employee comes to work with a scratchy throat, but they have been vaccinated, or they have allergies, would they need to be excluded from the workplace because of their symptoms? And what if they take a COVID test and want to stay out until they receive the test results, even if they're vaccinated? So this is going to depend on the nature of your workplace. It's going to depend on what your COVID-19 plan says and what is reasonable to protect your employees. So as the pandemic continues, it's going to be, and more people are vaccinated, it's going to be less important to keep someone out with a scratchy throat. It really depends on what that employee is doing, whether they can maintain social distancing, whether they're wearing a mask. So this is a lot about the individual nature of your workplace. You can ask employees to bring in doctor's notes. This employee has asthma and periodically has a scratchy throat. It's not COVID. You could ask the employees to get tested. If you ask them to be tested, then that period in which you're asking them to be out of the workplace may potentially need to be compensated. And that's something that you would want to address with an employment lawyer potentially, regarding why an employee is being asked to be excluded from the workplace. And so this is all kind of on a case-by-case basis, how much, and we dealt with this earlier in the pandemic in terms of if an employee has been exposed to someone who's been exposed, there's no legal mandate that they be excluded. But a lot of employers were wanting to take that step because of just the amount of spread in their particular industry, in their particular workforce, in their geographic area. And so a lot of that is going to be up to the discretion of the employee. There is no hard and fast rule on who has to be excluded. It's much more at this point on a case-by-case basis. Though a lot of employees do still have their screening in place. Schools are sending the screening links every day, for example. So you may fall under a regulation that requires that kind of screening. In that case, you might require more documentation. It's all going to be based on your particular workplace. Are there updates for outdoor business places? For example, outdoor recreational businesses. There are no current mandates in place for the operation of outdoor businesses. The prior recommendations that existed for like recreational facilities still exist, and you can look to them as guidance and guidelines for what you should do to take reasonable steps to make your workplace safe, which is what Cal OSHA requires of us and what maybe should be included in your COVID prevention plan. The fact that there aren't stay-at-home orders or reopening requirements doesn't mean that there are no obligations to maintain a safe workplace from COVID anymore. So that's what you're going to look to. There's no specific mandates unless you are hosting a mega event with over 10,000 people outdoors. If you have youth activities, they may be covered under masking or vaccine. Actually, masking, no, because it's an outdoor activity is what you told me, but may be covered under some of the vaccine mandates for school and childcare and child activities. If you're requiring unvaccinated employees to be tested as a voluntary private employer policy, so you're requiring it, but there's no state mandate that requires it, I would recommend that you pay for that testing. Under California Labor Code Section 2802, employers have to pay for workplace related expenses. And if a vaccine or if a testing mandate is part of your workplace, then that is likely to be considered a workplace related expense. The safest thing to do would be to pay for that. How strict do we have to be with religious exemption requests? This is going to be a question that I would say you're going to want to consult with your employment lawyer on. Employees Employers are ranging across the spectrum at this point, depending on what type of business they are, how much customer contact there is, and how much risk they think there is in their workplace. And that all has to be weighed against employee religious exemptions and religious freedoms. So some employers that I work with want to take a more lenient approach and not really investigate. And then we see in the news, for example, some large corporations which are taking a really hard line on this and want their employees to attest that they don't take ibuprofen, for example, because it has been tested on stem cells, so developed from stem cells. So we see the gamut. Somewhere in between is probably going to be the most practical approach, but that's a question I do recommend you address with an employment lawyer for a better understanding of what risk your business faces on either side. Would I be willing to share my form? No, that is something that I provide to clients after consultation that I tailor to their needs. One of the aspects of my practice is providing forms, policies, templates, but I do that within the context of a consulting relationship where I'm familiar with the specifics of your business. So I don't provide my forms generally to non-clients. For example, I have CFRA forms that I provide to clients that we do employee handbooks for, and those came out last year, and I provided all of our clients who did employee handbook updates with us with those forms. So that's something that we do provide for our clients at Kroloff, but I don't just provide them generally to the public. How can we know that a letter is misleading, even if the person has told us something to the contrary? I think this pertains to a religious exemption. If you have a reason to believe that the religious exemption documentation is false, then I think there is some potential liability there for accepting it. Potential liability in the event that person, for example, spreads COVID. But this is one of the ones where I would say this is the type of question that's high liability. The people providing religious exemptions tend to be very conscious of their rights, and they want to enforce them, especially if they have a sincerely held religious belief or if they're going to fake one. So that's a question you're going to want to ask an employment attorney based on the specific circumstances. Verification of vaccination is required for employers with 100 plus employees. Yes, under the federal OSHA regulation, it is the California OSHA, Cal OSHA is expected to adopt a similar rule this week, actually, or next week, I think it is. That rule on the federal level was stayed. So it's not currently being enforced, but yes, you would be required to keep documentation. How do you count whether you have 100 employees? That is going to depend on the law that is being enforced. So we saw different enforcement. This is why people hate employment law. Every California law, every federal law counts employees differently. So that's going to depend on the specific law being enforced. We haven't seen the Cal OSHA regulation yet, and I don't know off the top of my head the rule for the federal OSHA rule on terms of how they count employees. It's probably how federal OSHA counts other types of employees. For example, California paid sick leave was more broad than some other laws. In California, I'd say you would be required to provide testing costs, yes, because the testing is being done for the purposes of the employment. Are you allowed to require testing or vaccination in a private workplace where it's not mandated? Yes. Those types of restrictions have by and large been upheld across the country. We're seeing different challenges in different courts. This area of the law is still evolving, but there are employers who are requiring testing weekly without there being a mandate. They're paying for it and providing the time off for the employees to do it or conducting it on site. I have several clients that operate group facilities where they have contracted with a testing company, and they provide the testing on site, and then they FedEx it and get results back within 24 to 48 hours. So if you're looking for something like that, I can give you a recommendation if you want to email me. But there's quite a bit of companies out there now doing that kind of remote testing for employers who want to do routine or sample testing of their workforce. I have a question. Can we use sick pay before using COVID pay? So the California COVID sick leave law and the federal COVID paid leave laws have expired. So at this point, yes, the Cal OSHA requirement that you pay exclusion pay to employees who've been exposed in the workplace allows you to pay on top of other benefits that are provided. MJ, I will email you about the 100 and how it's counted. What resources are available for small businesses that do not have HR or a legal team? I recommend using the California Chamber of Commerce products. They do have some nice products for smaller employers that I can't endorse all of their products. I haven't read them specifically, but I do have clients who have used their products and find them helpful. They have, for example, checklists for what documentation has to be provided for new hires. That's also something the type of materials that I provide to my clients. So if you have an employment lawyer, you can seek information there. I will be giving a general California employment law overview presentation in December and January for all of the updates. So you can check out those. The Kroloff website has a whole set of videos on different employment law topics and several COVID topics if you want to check out those. Nancy, you've asked me a question about the 300 log. If you could please email me that question, I will get back to you on that. I want to look that up to make sure I answer correctly. Rosie, you've asked me a question about COVID pay and whether an employee has to be employed for a certain period of time to be eligible. I'm not sure what you mean by COVID pay. So if you want to provide a further explanation of that, I can answer that question. Or if you want to email me, we can maybe have a quick call offline. The emergency temporary standard does require pay for vaccine-related symptoms. There is no outside time frame for that. My understanding is that I haven't seen personally COVID vaccine side effects lasting more than a day or two. But if you have someone suffering for longer, there's some other laws that may come into play. Maybe that's a serious health condition. Maybe it has triggered another underlying illness that's protected in some other way. Maybe it's a disability. So that's something I think you would want to run by counsel for that specific instance. Okay, I think I've answered all of the questions that I have in the chat and the Q&A. So I want to say thank you to all of you for hanging out with me here past 1 o'clock. I hope this was helpful. I'll continue to do these as things evolve and as the law changes so that you have an overview of what's currently in place for you to reduce risk in your workplace for either claims or illness. I appreciate all of you. Check back with us and see our website for some upcoming webinars that we will be doing in December and January on kind of all different types of employment law and different risk reduction strategies that you can take. And I'll have some HR recommendations for you in those. Also, you may have received, or you will be receiving next week, an email on some legislative updates that came out of the legislative session that closed in October. And you can take a look at that and let me know if you need for those of you who are my clients, let me know if you want your employee handbook updated before the end of the year, because it's coming up fast. So thank you, everyone. Have a good weekend and good luck to all of you.